May have their perceptions. Remember that when people find themselves at the wrong side of the law, they look for a convenient way out. If you steal somebody's goat, is it your goat? As to how they are treating you, using material, not so.
Muntie, yanio, akofaba muntie, Edum TV fwa akofaba muntie yanio, mofa muntie arefwe.
Edum TV.
Yeah, you do.
A very good evening and heartfelt welcome to everyone watching Edum TV, where we bring to you the culture, practices and traditions precisely of the Ashantis. Today, we bring to you the launch of a great book titled The Law, Practice and Procedure in the Superior Court and Appellate Tribunals in Ghana. And we are in the third floor of the Court of Appeal building. We are in the midst of three intelligent authors here came together to bring this book into being, and one of them is Mujib R. Ahmed, who is a senior lawyer, and we are very privileged to have him here to discuss one or two things about the book with him. And so we'll just go straight into action and then talk to lawyer Mujib R. Ahmed, who is a senior lawyer. My name is Sweetie Nana. Lawyer, may we welcome you to Edum TV.
Thank you so much, my dear.
Lawyer, the title of the book is The Law, Practice and Procedure in the Supreme Court and Appellate Tribunals in Ghana. You are one of the authors of this great book. Lawyer, how did this title of the book come into being?
Thank you so much, my dear. You realize that during the launch of the book, we indicated that the law thrives, or the justice delivery system thrives, on three pillars. Yes. And that you find this in some of the decided cases. And without trying to, if you like, be a little technical or be boring to the viewers and listeners, you remember I started the case of Harley versus Ajura Farms. Yes. And for the records, it's reported in the 1977 2GLR 179 Court of Appeal decision, where Taylor J. as it then was, indicated that justice in this our dispensation is administered by reference to only three yardsticks: statute law, case law, and well-known practices of the court. Now, if you take the book, the title, Law, Practice and Procedure, it attempts to bring together these tools that are used in the justice delivery system.
Thank you very much for making us know how the title of this great and intelligent book came into being. Lawyer, as we move on to our next question, we would like to know, lawyer, is there law in Ghana, in our system here, Ghana, currently as we are in the 21st century? Is there law?
Yes, there is law. Otherwise, you would have heard that even under the military rule, there's always law. You realize that even when there is military rule, the legislature will be dissolved, executive will be dissolved, but the judiciary always remains. So as we talk now and as we speak now, we are under constitutional democracy. It means there is law in this country.
But, lawyer, there is a perception that the law in Ghana only favors the rich. That is our perception. Not only me, most Ghanaians have that perception that the law in Ghana favors only the rich or the well-to-do in this country. Lawyer, is it true?
No, I don't think that is very true. I don't know of any law that says that law for the rich and law for the poor. If you know, you let me know. The law is no respecter of persons. All right?
Yes.
So people may have their perceptions. Remember that when people find themselves at the wrong side of the law, they look for a convenient way out. If you steal somebody's goat, is it your goat? As to how they are treating you using material, not so. You have stolen. Do you understand what I'm saying? Yes, you go and take somebody's money. It's not your money, and then you say that, oh, because I'm poor, I shouldn't go through the criminal procedure. Is that what you are saying? Yes. So the law is no respecter of persons, and there is law for everybody, because at the heart of every democracy is equality before the. In fact, the rule of law, and deep inside the rule of law, is equality before the law, and the fundamental nature of the law as the basis for governance and for ordering people's conduct in society. Law has always been. In fact, even if you look at the jungle itself, there is law. When the lion makes noise, all others give way. Not so. Yes, there is a law even in the jungle. Yes. So you can't have a lawless society. Otherwise, you go to Plato's state of nature, where might is the order of the day. When you are coming here, did anybody stop you not to come?
No, nobody stopped.
Yes. If there was a lawless place, you would have been beaten up and your microphones taken away and all of them thrown off. Not so.
Yes.
We may not like the issues as they are now, and we may think that, and in any case, with the benefit of hindsight, as we were indicating, there is always a better way to do things. But it doesn't mean that what we have doesn't exist. It exists. But there is room for improvement.
Lawyer, I understand every bit of what you have said, but I have heard of instances where people normally say, let's say, for instance, I have a case with someone and I am quite well to do than the person. And if this case is taken to the court might or sometimes decide to favor me, the well to do, and then go against the person who is not that well to do. I have heard of such instances. Maybe sometimes the person might be taken to remand, coming back to court, going back to remand, and before you realize, the case will be dissolved. You wouldn't hear of any positive result.
I'm happy that you said you have heard. Have you seen?
No, I haven't seen, but I have heard.
So, for hearing, it means that you have just heard it somewhere. I'm saying that I haven't heard and I haven't seen.
Okay.
What I know is that if you have a case, use the proper channel. Okay. If you go and then somebody else tells you that, oh, you come and tell me for me to go and report, and you now use a third party, and the person is unable to present your case for you, that's your problem. Okay. Yes, you go and make a report if it's a criminal matter. If it's a civil matter, you go and see a lawyer. And then the lawyer issue the appropriate rate and send it to the appropriate court. And then you have your reliefs. You have your remedy in court. As for what people say, they will say it. Do you understand? Yes. But it's I don't think that is what it is. There is law in this society. We are not living in a banana republic. No. This is not a banana republic. It's a constitutional democracy. That's what we are running.
Lawyer, may we move on? And I think you are in a hurry, but we want to ask one or two questions so that, yes. Lawyer, is there an instance where sometimes a lawyer might have one or two misunderstanding with a judge because of a case? Has this ever happened before?
You may disagree, not misunderstanding.
Okay.
Yes, you may disagree with the position of the judge, but it's not a misunderstanding. And the law is not like mathematics, where 1 + 1 is equals to 2. No. You may have an issue. Look, there are so many cases. If you read in Appellate, now the matter went before the Supreme Court. One judge said that, look, why don't we use the implied repeal principle? That if you have a provision and then a subsequent provision comes that is contrary to the first one, we should imply that the second one has impliedly repealed the first one. Okay. Now, and he got to a conclusion. Another one says that, look, why don't we adopt the doctrine of general and specialibus? That you have one provision that is specific and then another one that is general in nature. For instance, there's a law that says that all radio stations, you are supposed to pay an annual, if you like, tax of 10,000. But Adom should pay 500. Now, upon the application of the doctrine of general special abuse, you can't apply the general one that says all radio stations, because you have a specific one that deals with Adom. And then the judge adopted the general special abuse, and they all came to the same conclusion. So that is how the law is. It is not 1 + 1 = 2. You put your case before them, they apply the legal principles. If you as a lawyer, you disagree with their application of the particular legal principle, you are at liberty to go on appeal. Okay. That's why the appellate process is there for you to correct. So you remain with the court system. You go on appeal, challenge it. As the learned former Chief Justice said, look, the thing about appeal is that you can simply define appeal as an application to a superior court or a higher court to correct an error committed by a lower court. So you appeal it and claim, and then put the error there. Put your case as it is. You put your disagreement with the first judgment as it is. And the appellate court, if they agree with you, they will overturn that of the lower court. Yes. So there is no issue of, if you like, it's not a confrontation, it's a disagreement. And we are not, even the judges, when they sit as a panel, they disagree. You have heard of decisions where you have 3-2, 4-3. Yeah, they have disagreed. The same situation. So how about we, the lawyers? We can disagree. And when you disagree, your remedy lies in an appeal. And then you proceed.
Thank you very much. And lawyer, sometimes I don't understand, or I begin to wonder. The police know the law. Let's say someone has stolen something, and the law says if a person steals, let's say, a mobile phone, he has to be jailed for 5 years. The police knows that law. Why don't they just arrest the person and then put him in prison for him to start serving, but rather take the person to court?
I told you we are not in a banana republic. Do you see? If that's what you are saying. If I now call the police and say, oh, you have taken my phone away, they should take you straight to prisons. Is that what you are saying?
That is what I don't understand.
Look, there are processes to follow. Okay. We are in a constitutional democracy. The rule of law is the basis for governance. Yes. And therefore, when you are coming under the rule of law, every accused person is given the benefit of the doubt. Okay. By giving you the benefit of the doubt, we presume you to be innocent until where you yourself plead guilty or you are proven guilty. Okay. Do you understand? Yes. And therefore, if you now say that somebody have taken your phone and the person has not pleaded guilty, he will have to be proved guilty. And the only place to do that is before the court. And remember that you cannot condemn any person unless or until you have given that person a hearing. We call it the odi otram partem principle. Wow. And we said it's inherent to nature. And that God in his wisdom have decided that before you condemn anybody that you have accused of doing something, you must give the person the right to hearing. Didn't God give Adam and Eve, didn't he tell them not to eat a certain fruit as we are told, even though we are told that fruit is not the fruit as they want us to believe? All right? But even when they ate the fruit, he didn't go ahead to condemn them. He gave them the hearing. It was not until they failed to give a satisfactory explanation that the punishment was pulled down on their heads. So you can't just assume that, look, and then somebody have stolen. Oh, police, jail. Police don't do that. They don't have those powers. And that kind of posturing is a call to, if you like, jungle life. And I think that should not be the way to go. Let the person be taken through the processes. If he's found guilty, the long arm of the law, the hammer will be pulled down appropriately as prescribed in the statutes.
Thank you very much, lawyer. I think we have just some 2 questions to go. Lawyer, now coming back to your book, what do you seek to achieve from writing this book?
I've just told you that you can't deliver justice without reference to law, without reference to statute law, without reference to procedure. Now, I've told you also that the very learned Chief Justice in one of his cases in the nature of Agbevo versus Okansi in the 2009 Supreme Court of Ghana Law Report 703 at 706, he indicated that even when you have a right, including constitutional rights, you can only ventilate them within the remix of the rules of court and practice. Now, what it means is that your substantive right, the right that you have in saying that somebody has trespassed onto your land or somebody has defamed you in substantive law, you need to use the procedure carved out by court and practice to be able to get a remedy. This book provides that channel, that link between substantive law and procedure as the basis for justice delivery and dispensation in our country. And as I indicated, that much earlier in the case of Halley versus Ajura Farms, these were stated, and that was approved by the Supreme Court in the case of Opon versus the Attorney General, 2000 Supreme Court of Ghana Law Report, 275 at 280.
Thank you very much, lawyer. And then to our last question, lawyer, what are the stages of the courts? Which is the highest and which is the lowest?
It is the Supreme Court. The Supreme Court is the highest. And then the lowest in the regular courts is the district court. But you also have the houses of chiefs, you know. So you have the traditional council, you have the regional house of chiefs, national house of chiefs, then you connect up to the Supreme Court. That's the hierarchy we have. Yes. Yeah.
Thank you very much, Senior Lawyer Mujib R. Ahmed. We just spoke to Senior Lawyer who is in the person of Mujib R. Ahmed, who is a senior lawyer. He is one of the founding fathers of the book we just launched, which is titled The Law, Practice and Procedure in the Superior Court and Appellate Tribunals in Ghana. The authors of this book are three, and Lawyer Mujib R. Ahmed, who is also a senior lawyer, is one of them. We also have Lawrence L. Mensah, who is a retired Court of Appeal judge, and also Lawyer Kwamena Mensah. These three men of substance are the proud owners of this book. And then so many dignitaries were present to honor the book launch of so many dignitaries were present to honor this book launch, such as His Lordship Justice Anim Yabua, who is the former Chief Justice, and also Nana Bafwan and Tahene, among others, were present here. And I am highly mesmerized at the in-depth knowledge this book seeks to give. And I encourage everyone, not only lawyers or judges, but every individual, irrespective of one's career, race, or identity, to have a copy. And I believe you will never regret. Lawyer, please, may we ask whom, or do you have some three or more people you would like to give thanks to concerning your book?
You will recall that at the last Awokudai, we were there to present the special edition of this book to His Royal Majesty Otumfuo Osei Tutu II. And in fact, we also dedicated the book to him. And the dedication reads that he was a generational king, a distinguished and outstanding African king, a pillar of hope, peace, and development in Africa. You know the exploits of His Royal Majesty in solving so many problems, both in Ghana and outside Ghana. Only about 2 weeks ago, he was at Trinidad and Tobago, and he was talking about developmental issues that will benefit Ghana and benefit Trinidad and Tobago. So we felt that having seen some of the things he has done, in fact, even recently, the trouble that was in Boko, because of his efforts, we are almost out of the rules. And so we felt that this was the need for us to dedicate this book to him as if you like, the father of the nation. And we so dedicated the book to him. And we are grateful to him also for allowing us to serve him for some time now. We are grateful to His Royal Majesty.
Thank you very much, lawyer.